hope in the other, and see if that helps. Bond set at $5,000 on the meth, $1,000 on paraphernalia, $500 on the driver's license, which oddly enough, the Supreme Court said you do need to drive. Court date is February the 17th at 9 o'clock, but you're not going anywhere because you got that probate or that parole.
Step to your right. So the team.
Mr. Fox, when you sue me, make sure you spell it with 2 N's. I want to make sure that the AG's office gets involved.
You don't have to worry about that, sir. I'm peaceful.
Sign where the light is for your copy of that. Next.
The judge takes control, breaking down the charges for the defendant who struggles to comprehend the legal terms. This is a perfect demonstration of judicial patience meeting confusion. Watch as the judge sets fines, explains consequences, and establishes the court's authority, while the defendant fumbles to follow along. Tension rises as accountability is made crystal clear.
All right, so that was a nice way to return from the holidays. Speaking of which, I hope you had a Merry Christmas and a Happy New Year's as well. For our next soft hard, we head to Bothell, where we have an educationally insignificant sovereign citizen who doesn't consent to following the law.
All right, it's off the 11 o'clock calendar. Mr. Calzada, could you please turn on your video for me?
Yeah, hold on one second.
All right, good morning, Mr. Calzada. You're here for arraignment, so could you please tell me your full legal name?
I don't know how that has anything to do with a case. My name.
Well, Mr. Calzada, I need to confirm who you are. So could you please tell me? Well,
I'm here physically present, right?
Mr. Calzada, could you please, what is your first name?
My first name? Well, it could be anything, right? I could change my name at will, right?
All right. I'm going to set this matter over for an in-person arraignment, and Mr. Lohr, you'll have law enforcement standing by. All right?
Well, there you are.
All right. So, Mr. Calzada, I will set this over. You will appear in person at the Bothell Municipal Court for arraignment.
I don't even consent.
Here, the defendant challenges the court, questioning authority and consent. The judge calmly asserts jurisdiction, explains why the defendant must appear in person, and highlights that law applies regardless of personal beliefs. You can feel the clash of personal ideology versus legal reality. The courtroom tension peaks as the defendant struggles to assert control, but the judge keeps the process moving.
And you guys were all doing Snohomish County prisoners. It's pretty busy, huh? The sheriff even said it's pretty busy. The court has to file a 1099-C. How you file a 1099-C for that bond? You don't need voter approval for that, don't you, those bonds? How much are the bonds?
Mr. Calzada, I'm going to set this to December 31st at 1:30 in the Bothell Municipal Court in person. You will need to be there for arraignment, okay? So I will see you in person at the Bothell Municipal Court at that time, all right?
Looks like there's no free will then.
So
then what am I doing here then? Hold on, what am I doing here?
Well, right now you are not responding to my questions. So
well, you're not responding to any of my questions. I don't have a problem of answering any of your questions, but I have a couple questions first. I have to understand too. I don't understand what's going on. I don't know everything. I'm not.
Attorney attempts to withdraw, claiming communication issues. The defendant disputes this, asserting that the attorney isn't doing their job. The judge steps in decisively, enforcing courtroom decorum. This clip is a showcase of procedural friction and courtroom management, where the judge prevents a breakdown of authority and maintains order amid conflicting claims.
Come in person so that we can be sure that you understand what's going on.
All right, great. I'm glad. It's definitely implied, isn't it? It's not expressed. It's implied.
December 31st at 1:30 in person.
December 31st at 1:30, I'll be there.
Very good. We'll see you then.
The judge delivers a firm ultimatum, stop disparaging your attorney, or face contempt. The defendant is forced to choose between self-representation or a new court-appointed attorney. The tension here is palpable. It's a masterclass in courtroom control, showing how patience and authority can guide even the most resistant defendants toward resolution.
You don't have the first clue when it comes to things, and you talk about that. And so Mr. Gazicki is saying that he's trying to talk to you about actual legal defenses, and you're trying to bring up some kind of other stuff. And so I'm going to grant his motion. Do you want, all I asked you was this. I didn't ask you to give me a commentary about Mr. Gazicki or what you think he can do, because I've always seen him to do his job every single time he does a file. What I want to know is, do you want another court-appointed attorney, or are you representing yourself? That's it. It's a simple question. Answer simple questions. That's what you needed to start doing, is answering questions.
Yep, one other attorney, but I don't want to state also that if it was recorded, that we would say it would support my allegations.
Boom, time out. Nope, not hearing it. The question is this: do you want another court-appointed attorney? So you're either going to say yes, court-appointed attorney, or represent yourself. What is your answer here today? Because there's only two possible answers here. You either get another attorney, or you can represent yourself if you'd like, or if you want to hire your own attorney, you can do that. So there's three things. Are you going to get one appointed, yourself, or retained? Those are the three possible answer choices. What are you going with?
Yes, another appointed one, but without.
All right, there you go. Don't need any more commentary. Don't need any more commentary about it. You have a right to remain silent. You can exercise that right now. So we're going to appoint another court-appointed attorney to you. And the individual who was here as your attorney during your trial, you seem to get along pretty well with him. You want me to reach out to see if he's available?
I don't know who you're referring to.
The guy who was here at your trial. I don't know his last name.
Oh, he's on the other trial.
Yeah, the other trial, not this case. This is the misdemeanor domestic violence case. I'm talking about your driving on a suspended license case, restricted.
Well, I mean, he did for the most part. Well, I won't say for the most part, maybe for the most part, but there's some things he didn't do neither. He should have. He didn't raise my right to travel defense. So
yes or no? Yes or no? Is he somebody that you think you can get you can communicate well with?
I guess we'll give him a try. I guess. Yeah.
Sure. All right. I'm going to appoint or reach out and see if we can see if he's available. So let's appoint.
But now, Slayton, I have some questions for you before you move forward.
All right. So we're going to set that. We're going to set that for a hearing date, and we'll see you then.
Hold on.
We shift to a new defendant at an informal hearing. The magistrate begins by introducing the process, while the defendant questions authority, trying to sidestep compliance. This clip perfectly illustrates the opening of a legal battle where procedural expectations collide with personal beliefs, setting the stage for the ideological showdown that follows.
My name is David Heiss. I'm an attorney magistrate. We are scheduled for an informal hearing in two different cases that arise out of one citation. And those Correct. Two cases are both entitled The People of the City of Battle Creek versus Roosevelt LaShawn Williams. Is that your name, sir?
That is my name.
Basically, what happens is you were issued one citation. It had two violations listed on it. So it became two different cases, one with an A and one with a B at the end. But we have one informal hearing scheduled for both of those cases because they both arise out of the same transaction, so to speak. And I guess, Officer Kellums, is there anything before I begin?
No, sir.
All right. Mr. Williams, you're here because you were issued a citation. And in each of those two cases, so for each of those violations, you have three possible responses to the citation. You can first admit responsibility, be assessed the fines and costs, and be done with it. You could, as a second option, admit responsibility with an explanation, hoping that the explanation would cause the court to decrease the fines and costs a little bit. Or you can deny responsibility and have your hearing. It's my understanding that as to both cases, you wished to deny responsibility. Is that correct?
That is correct.
Okay. Well, here's how the hearing works. First of all, I guess I should read the citation. In the case ending with the letter A, it's alleged that back on November 19th of 2024, you were over at Fountain Street near Meacham Avenue in the city of Battle Creek, and you were issued a citation for not being able to provide a proof of insurance. This is a civil infraction. If you were found responsible, all other things being equal, the court would assess $125 fines, costs, and fees. It is a 0-point ticket. And in the second case that ends with the letter B, that same date, time, and place, you were issued a citation for having an expired registration plate. That is also a civil infraction. It is also a 0-point civil infraction. If you were found responsible, all other things being equal, the court would assess $110 fines, costs, and fees. So first question, is that the ticket or the two cases that you thought you were appearing about, Mr. Williams?
It is.
Okay. And same question to you, Officer Kellums?
Yes, sir.
Very good. In every civil case, the plaintiff has the burden of proof. And in a case like this, that burden of proof is called by a preponderance of evidence.
Only question I have is, will the laws of the U.S. Supreme Court be applicable? And the federal statutes and definitions of motor vehicle and automobile be applicable in this proceeding?
They are the state of Michigan laws that will be applicable.
Okay. The other question is, are you already not bound by U.S. Supreme Court rulings?
Every court is bound by relevant Supreme Court rulings.
Okay. All
I'm
right.
not quite sure.
The magistrate lays out the civil infractions and possible responses. The defendant asserts denial of responsibility, questioning the law's legitimacy. Here, the tension escalates as the magistrate patiently explains the charges, giving viewers insight into the careful balance of explanation, patience, and authority in courtroom proceedings.
Right hands. Very good. All right, Officer Kellums, if you would begin, please.
So on November 19th, 2024, I was on patrol for the Battle Creek Police Department when I observed the vehicle that Mr. Roosevelt was driving. I observed that it had expired tags on the vehicle. I then conducted a traffic stop on Fountain Street near Meacham Ave. Found Mr. Williams to be driving the vehicle, where I issued him the citations. When speaking with Mr. Williams, he could not provide insurance, and his tags were expired.
Okay. Do you happen to know when they expired?
I do not off the top of my head, sir.
Okay. What made you think they were expired? The wrong color and the wrong year on the plate itself, or some?
Yes, sir. Yes, sir.
All right. Did Mr. Williams say anything to you during the stop about having insurance or not having insurance, or anything about the tags on the plates, anything like that?
He informed me that he did not have to have insurance due to that he was traveling, and to drive a vehicle, you have to have insurance. Something regarding Supreme Court. That's about all he said.
Okay. All right. Do you want me to consider anything else at this point, Officer Kellums?
No, sir.
Okay, Mr. Williams, could you hear Officer Kellums' testimony?
Yes, I heard his testimony.
Very good. Thank you for your patience. What do I need to know, sir?
Okay, I did inform Officer Kelly that I am not operating a motor vehicle, but I am operating an automobile. I did inform Officer Kelly of the ruling of Rodriguez v. Ray Donovan, U.S. Department of Labor, 769 Federal 2nd, 1344, where the U.S. Supreme Court's decision has ruled that all codes, rules, and regulations are for government authorities only and not for human creators. In accordance with God laws, all codes, rules, and regulations are unconstitutional and lacking due process.
All right, I'm going to interrupt you just for a second. Are you telling me that a case at 769 Fed 2nd, 1344 indicates that all laws are unconstitutional?
All codes, rules, and regulations. Yes, sir. Rodriguez v. Ray Donovan. And if I'm not mistaken.
And you said that was Department of what?
U.S. Department of Labor.
Okay. U.S. Department of Labor doesn't publish decisions in the Fed 2nd. Can you tell me a little bit more about the case? What was that issue in the case?
It was regarding what we're discussing here, the requirements of a driver's license and the need when it's required to have one, stating that when you're not operating in commerce, to which I informed the officer that I am not operating in commerce as stated in USC 18 USCA 31 paragraph A6 states that a motor vehicle, the term of motor vehicle meaning every description of carriage, contrivance, propelled or drawn or mechanical powered and used for commercial purposes. This is what Title 18 USCA Section 31A6 states or defines as a motor vehicle, to which I am not operating.
The defendant launches into a sovereign citizen argument, citing obscure cases to justify noncompliance. The magistrate interrupts to clarify the law, exposing misunderstandings. This is an ideological clash in full display, highlighting the defendant's creative legal reasoning versus the magistrate's disciplined application of statute and precedent.
Happens in terms of the Michigan legislature defining in Chapter 257 what a motor vehicle is, and an automobile under Michigan law is a motor vehicle. But okay, continue.
Right, it's a motor vehicle, which is described as anything, even by the Michigan compliance statute of 751, which you just stated, is determined as something that's transporting goods, which I'm not transporting goods.
I understand your position, and I can tell you that that position doesn't happen to be legally correct. But go ahead.
So you're basically stating that there's a misinterpretation of what's in black and white?
No, I'm telling you that you have misinterpreted the application of 18 USC 31A6 and 769 F second or Fed second 1344.
Okay,
but
well, I see what
I've heard your
going,
argument.
So there will be no further arguments because I see that you're not going to agree to, because like I said, I've given it to you, the cases where they're like Shapiro v. Thompson, where the U.S. Supreme Court has said that a driver license is not a requirement, that you're trying to convert a right into a privilege, to which is covered by Article 1, Section 8.
I'll ask you this. Is that right, the right to travel?
That is a right to travel, convey, however you want it, by the U.S. Constitution.
What you just told me was that somehow but regardless, am trying to convert a right into a privilege. Now, the question I have for you is, what right has been converted to a privilege?
My right to freely travel unencumbered and unfettered.
I will ask you this. How is your right to travel removed by receiving the citation?
By trying to require me to have a license to operate a automobile, which is my private vehicle.
Okay. All right. Is there anything else you want me to consider?
No, sir.
The magistrate dismantles the defendant's claims about the right to travel and motor vehicle requirements. The defendant persists, creating a dramatic tug-of-war between personal belief and legal reality. It's a riveting display of courtroom authority standing firm against unconventional defenses, illustrating how the law responds to persistent, unorthodox challenges.
Vehicle laws, including the laws that require you to carry insurance, that require your vehicle to be registered, and require that registration to be current, do not run in violation of any right to travel under the Constitution or the United States Supreme Court decision that you have cited. In fact, Michigan courts have held that essentially the right to travel means the right for you to move from A to B, not the right for you to travel from A to B under your most convenient way. So you could walk from point A to B all you wanted. You could take a taxi or an Uber or a plane or a train or a bus. But if you wish to travel by using a motor vehicle, the Michigan laws are applicable and don't unconstitutionally interfere with the right to travel. It doesn't convert the right to travel into a privilege. You are not denied the right to travel. You may be denied the privilege of traveling via a motor vehicle that you are operating. So
Okay, so I
that
stop
is
you.
that is what the law says, and that's what I'm finding. Is there anything
Okay,
else you
so
want me to consider about that finding?
Shuttleworth v. Birmingham, U.S. 147. Do you mind telling me what the U.S. Supreme Court ruled in that?
US 147 doesn't give me the site of a case. That's an
Uh,
incomplete site of a case. Okay.
it was Shuttle.
And
I said
if you wish me
I
to
said
consider the case,
Shuttleworth.
why don't you tell me what was at issue in the case and what year it was decided?
I said Shuttleworth v. Birmingham, U.S. 147, 1969, where it
Okay,
says
you hold
no
on. US
license.
147 is not a complete site. The way you cite to a case is by name and then volume number and then the name of the publication and then the page number. So for instance, when you said 769 Fed 2nd 1344, what that means is volume 769 of a book or volumes called The Federal Reporter, second edition, at page 1344. So when you're asking me about this most recent case that you've talked about, what you said was US 147, I think. That's not the citation to a case. So you're going to have to tell me more about that case. Who were the
Okay,
parties to that case and what issue was before the Supreme Court in that case?
okay, so you didn't hear me cite the name of Shuttleworth v. Birmingham?
I heard you say the name. That doesn't
Okay,
tell me
and
what, that's not a complete cite of the case.
all right. Do you not have the documents that I filed when I filed to say that I want to have an informal hearing? The affidavit that writes that my
There are documents that have been scanned into the court that you dropped off.
okay.
So
So
from
even
those
if
documents, why don't
Here, the magistrate clarifies Michigan laws, distinguishing personal travel rights from the requirement to register and insure vehicles. The defendant resists the interpretation, leading to a tense but informative exchange. This clip demonstrates the critical role of clear, authoritative explanations in maintaining legal compliance, while revealing the defendant's unyielding approach.
actions are not crimes, blah blah blah. Person faced with
Right.
okay.
Traffic
Uh
infractions are not crimes. That's absolutely correct. They are
okay,
civil
no,
infractions for a reason.
I was reading from a different case, but the case that I'm citing from states that no license necessary to drive an automobile on public highways, streets. No license is necessary. The word operator should not include any person who solely transport his own property and who transport no persons or property for hire or
Where's that
compensation.
citation from?
Okay, I just appeal it, and that way I can make sure all citations are
That's fine. I mean, the idea is I can't look up what you're telling me, right? Without a
okay.
proper citation. So you can read, I mean, for all I know, and I don't mean this, I'm using a farcical example. For
Okay.
all I know, you're quoting the municipal court in Honolulu, Hawaii, which has no
Right.
jurisdiction over Michigan.
It's
right?
understandable.
I don't
Okay,
know.
so I would cite Payne v. Massey, 196 Southwest 2nd, 493, Texas, 273.
Okay. Well, and I can tell you that Texas law, a court interpreting Texas law, that decision wouldn't be controlling on a Michigan court. But that's fine. I think I understand where you're going. If you want, I don't need to consider anything else. I'm just asking you, is there anything else
Okay, well,
you want to present to me?
if you're not going to consider anything else, then we can proceed on to your ruling, of which I know you're going to find. So, and like I said, like you said, I have a right to appeal it. So
Yeah, and I'm willing to listen. If you're going to quote something, I need to know what you're quoting, and I need a proper citation so I can look it up myself, right? Because otherwise, people could just run around quoting Mickey Mouse if they wanted.
right, okay, so
Nothing against you. So the question to you is, what else do you want me to consider at this point that you haven't yet told me?
Okay, Zobel v. Williams, 457 US 55.
And why are you citing that case? What is it telling me?
Because it states that let me see the above blah blah blah, to travel unencumbered and fettered on common public way or highway, which is their right to so do.
Absolutely.
Held that the right to travel is constitutional protected.
The defendant cites incomplete or irrelevant cases. The magistrate insists on proper citations for any argument to be considered. This moment is a masterclass in courtroom discipline, showing viewers how accuracy and adherence to procedure are enforced and how frivolous or incorrect claims are systematically addressed.
Sir, no.
Okay. I have no problem telling you have the right to travel. I have no problem telling you have the constitutional right to travel. All citizens do. No doubt about that.
One question. Is there a difference between a motor vehicle and an automobile? Is there a difference?
Yes. All
Okay,
automobiles
so-
are motor vehicles, but not all motor vehicles are automobiles.
Okay, so is my automobile not my private personal automobile that's not being used in commerce?
I would have no idea the use of your motor vehicle, and it's not relevant to me for the purposes of deciding whether you're responsible for these civil infractions.
Okay. Well, I have nothing else for you to consider.
Well, very good. I'm letting you know the law does not make a distinction between your using the vehicle for personal reasons or you're using the vehicle for commercial reasons when your registration plate is expired and when you fail to show proof of insurance. Both of those are required.
The MCL language.
Both of those are required under Michigan law for anyone operating any motor vehicle. That's what I can tell you. So
correct.
If you're
a motor vehicle to which I am not operating a motor vehicle, and this is what we are trying to
I guess
operating
it's
my
not
automobile, not a motor vehicle.
I can tell you that an automobile is considered a motor vehicle under the Michigan Motor Vehicle Code. So that's fine. Is there anything else you want me to consider?
Nope.
Very good. All right. So I've listened very carefully to the evidence. I do find that it's more likely than not that when you were required to by Officer Kellums at a traffic stop show proof that your vehicle was insured, that you failed to do so, and that it is more likely that your not your operator's license, the registration plates on the vehicle were expired. So I'm going to assess the $125 on the no proof of insurance case and the $110 on the expired plates case. All right. Thank you both for your time and patience. You're all set. Have a very good day.
Thank you, sir. You too.
You too.
Another heated exchange with the defendant attempting to quote cases to justify behavior. The magistrate maintains composure, emphasizing procedural rigor and legal accuracy. The audience sees a clash of persistence versus authority, highlighting the patience and expertise required to handle defiant courtroom behavior.